Good afternoon, everyone. We've got at least one person here by Zoom, and we've got several people live in the courtroom. It is the time to address our small claims matters. We've got some motions. We've got two separate cases. So we've got Daniel Schultz here by Zoom. He's here on Concrete and Excavating LLC. Good afternoon, Mr. Schultz.
Good afternoon.
We have David Nieves is here on his motion regarding Jorge Lopez. Mr. Lopez does not appear to be here. We have Acker Mechanical versus Sierra Diata. I don't see either of those parties presently. I have Dr. Smolar's office versus Rick Kupashek on a dental bill, and I don't see either of those parties. I do have an order to show cause in Amber Manley versus Ashley Furniture. Mr. Klopfenstein is here and Amber Manley is here. So let's address this one. This case has got a long, unpleasant history. Ms. Manley, would you have a seat over here? And Mr. Klopfenstein, would you have a seat over here? I was hoping this case was done, but it isn't. This is file 242120. This involved a long testimonial case about some lawn furniture that Miss Manley bought from Ashley Furniture. We had a hearing which was set for March 10th, and nobody appeared on behalf of Ashley Furniture. And a default judgment entered at that time on behalf of Miss Manley in the amount of $1,735.42. In an attempt to collect on that, then I got a motion from the, oh, you can have it. One of our cases has been dismissed. Then there was a motion to set aside the default, which I declined to grant. And so the motion, the judgment stands. And that was on April. In order to set aside a default, in fact, it's not even exactly clear whether you can even do it in small claims court, but I had a hearing. You have to show a legitimate defense and good cause for not appearing. I didn't find any good cause for not appearing. So the plaintiff then did a subpoena to discover the ability to pay on this debt, and nobody appeared from Ashley Furniture for that. So we set a show cause hearing regarding this. So, Mr. Klopfenstein, thank you for being here. Ms. Manley, you as well. Mr. Klopfenstein, will you raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
You so far have got about $10 zillion worth of bad publicity out of this case. I found on her behalf by default in the amount of $1,669.17, $62.28 for a total of $1,735.42. She wanted to add some other items, but they weren't part of the original complaint, so I wouldn't allow them to be added. You moved to set it aside. I denied the motion to set it aside. She did a subpoena to collect. She wants her money. You may feel that she was already made whole. She got the furniture returned plus other stuff, but this judgment entered by default. So the ship has sailed. You owe that amount of money. Do you have the ability to pay that?
Your Honor, we did switch out the piece for
I got it.
Okay.
I got it.
Okay.
But then the lawsuit was still going. You didn't show up, so a default entered on her behalf. You had a motion to set aside the defense. The default. You may have had a meritorious defense, but you didn't show up for the hearing. And I had a hearing to find out why, and there wasn't good cause other than I guess they forgot. So, yes.
I was out of the country and I did not know about it, but we thought it was made whole by exchanging the piece.
I understand.
We thought it was made whole.
It wasn't. And I didn't like entering the default. I thought she got paid twice. I thought she got made whole plus she got $1,600.
Yeah.
But you got notice, there was a hearing, she was here, nobody showed up, and a default entered. So yes, you got arguably double dipped, but you owe this money because you didn't show up. We're not going to revisit your defense. You weren't here to raise your defense. Then I had a hearing to set aside the default, which I'm not even sure I can do in small claims court. And I didn't set it aside. Now she wants her money. And then there was a subpoena and you didn't show up for that. I'm trying to determine when that was. That was, we did move it.
We moved it, yeah. It is.
You were to be here on 9/29. Oh, yeah, we moved it to this date.
Yes.
Not sure why this is a show cause. Just failed to pay, failed to appear for the motion, but I don't remember a subpoena for discovery. I'm not sure. It's an order to show cause why you should not be in contempt, but I don't see that you missed anything to be in contempt.
I'm sorry.
Yes.
I had to pay the St. Joe County of Mishawaka to have Ashley's furniture served.
I'm trying to figure out what date that was. I'm looking and it's not in the paper file in front of me.
And then he didn't show up.
Yes, I'm trying to determine what date that was.
I filed, oh wait, let me make sure.
Here's the subpoena. Subpoena was for him to appear on August 11th. And he did not appear. That's why you're in contempt. You got served the problem is you're too busy. You don't show up for stuff. So
I'm also out of Fort Wayne, not, we have a store in Mishawaka, but
yes,
maybe that's what was served. I am out of Fort Wayne.
let's see where the proof of service is. Picked up the plaintiff to have personally served on the defendant. Service of subpoena. It was served allegedly by a sheriff's deputy for St. Joseph County, which would be South Bend. Cost her $88 additional. Well, they served it on Ashley Furniture, Grape Road, Mishawaka, Indiana is where they served it, which is St. Joe County. So they served the business, not you. All right, at any rate, the judgment stands, whether it's fair or unfair, it does. So it was for a discovery hearing, for you to come here, for me to put you under oath so she could ask questions to you about your ability to pay on this debt. Now, you're not an attorney, and I don't hold you to that standard, and neither is she. We're in small claims court, and the rules are more relaxed, but they still are the rules of civil procedure. The hearing you failed to appear for on March 10th. I placed Ms. Manley under oath on March 10th and asked her some questions. And she still wanted her $1,699. Failed to appear for this hearing, which was noticed for that day. Then I had a second hearing regarding the request to set the default aside, and I denied it. So you owe her $1,735.42. And she's here because she wants her money, plus 88 additional dollars for the additional service.
Your Honor, may I speak?
Yes.
Yeah, the piece that the court had ordered us to replace, we did. We replaced it and everything.
I understand all that. You missed the hearing. So you want to raise your defense that you failed to show up for and raise the defense. So I was compelled to issue a default judgment. So you dropped the ball to the extent that it's cost you $1,735.42. I understand that you have some defenses you wish to raise. And I didn't enjoy entering this default judgment on March 10th, but you didn't show up. And then I had a hearing regarding why you didn't show up, and I didn't find good cause to find out why you didn't show up. So the ship sailed. You owe this money. Do you want to pay it, or do you want to get another $10,000 worth of bad publicity? $1,735.42 plus 88.
Do I not get the furniture back, Your Honor?
No.
So she gets the furniture?
Yes, she gets a double dip because of your failure to appear for the hearing, which is what stopped. You prevailed. I took testimony. She was unhappy with what she got. She wanted to sue for even more. Ms. Manlin, do you have any other expenses other than the $88 service fee?
Just my loss of wages for all of my work missed.
That's not recoverable in small claims. Was there a filing fee for the subpoena or anything?
Just what I had on the paper already.
All right. $1,823.42. What was scheduled was a discovery hearing. And it hurt to discover your ability to pay on the debt. You're here, she's here, you're under oath. I don't find that you're in contempt for failing to appear for that subpoena. The officer just subpoenaed your store, and then I don't know what they did with it, put it in a desk drawer or something, but they didn't give it to you and nobody showed up. So I'll take you at face value that you didn't know about that hearing. Then I did this, that you specifically had to be here so we could all be in the same place at the same time. But in order for her to do that hearing, she paid an additional $88 to have a South Bend, St. Joe County, Indiana deputy serve you. So that's where we are. It's difficult to execute on an Idaho state judgment. If this were in Michigan, she could seize your assets. She could come with a court order with a deputy and take money out of your till, I suppose. I don't think that's ever been done, but seize tools, trucks, that sort of thing to auction to pay the debt. This has been, you've been here 6 times. I don't know. You've both been here repeatedly. I've spent, I don't know, 20 hours on this case regarding this furniture.
This is the first time I've ever been here physically.
Okay.
I was at, before it was Zoom.
All right. Well, that's why I wanted to get everybody here. So the question is, are you willing to pay $1,824?
Again, Your Honor, she keeps the furniture, I pay her back for the furniture?
Yes.
And she's able to keep it?
Yes, 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 yes. I don't enjoy it. You didn't show up for the hearing. I took testimony. I default entered. She's still unhappy. She wants more than this. So I can't be any more clear. We had a hearing to set aside the default and I denied it. Yes, she gets the furniture and the money. So how does it, whether it's fair or not, that's how this came, because you didn't show up. So if you're not going to pay her the money, she can get an order to seize your property, and fight it out that way. But,
May I ask another question?
yes, sir.
And talking to my local attorney, he thought the jurisdiction would be in St. Joe County,
Jurisdictions at both ends.
where you buy it, because we have no stores in.
Yes, where she is and where you are. And it's a small claims case. The furniture was delivered to her in St. Joe County, Michigan.
Or picked up. I believe it was picked up.
And so,
A repair was
A
sent to
repair.
my house.
But the furniture was initially picked up in St. Joe County and at the store at the St. Joe County. I'm not an attorney. I don't understand.
I
a lot of the
understand,
things, you know.
but yes,
And our representative from Fort Wayne said he could not represent us in Michigan.
well, and you can't have an attorney in small
Yeah,
claims
that's
court.
right.
You can remove it to the general division of the court where she would have had a harder time presenting it following the rules of procedure. All I want to know is, are you going to pay her the money or not? If you're not, then I encourage you to then get an order to seize property. You've got so much bad publicity about this, then it should really have just been resolved a long time ago. She's very diligent.
With Your Honor, I thought it was resolved, so I apologize for that. And of course, paying, yeah, if you tell me where to send it, I will get it sent out.
All right, very good. Plaintiff will pay within 21 days. Her address is on the complaint and on the judgment. We'll give you a copy of that.
So I sent it to that address.
You sent it to her, not to the court, to the Youngs Prairie Road address, Constantine, 49042. That's still correct?
Yes, Your Honor.
Yes, I understand that you feel this was unfair. She also feels it's unfair, so maybe there's enough unfair to go around. I didn't like her getting the furniture and the money. It seemed unfair to me too, but I issued that order, and I'm not gonna say it for the 5th time. You didn't show up. So I'll have the bailiff take you out to the court office. The clerks will make sure we have the right address, and you should send $1,824.42 to Amber Manley at her Youngs Prairie Road address. All right, this was a very unpleasant experience for both of you, and for that I'm sorry, but I'd like this matter to be concluded. All right, $1,824.42 within 21 days.
Thank you, Your
All
Honor.
right, thank you. All right, thank you for coming all the way up here for this unpleasant experience. All right, you're both good to go. Mr. Schultz, can you hear me?
Yes, Your Honor.
All right, would you please raise your right hand? You swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief?
I do.
All right, the title of this case is Daniel Schultz versus Concrete and Excavating LLC Everlast. The claim is for $4,097.24. As in the last case, the plaintiffs have not, the plaintiff is here, the defendant isn't. So let's take a look. Somebody accepted certified mail service for this. Restricted delivery. certified mail returned. So they personally served Everlast Company in Granville, Sean Woodrow Jr., co-owner. So they aren't here to defend it. In your claim, you indicate you work with them, were given reasonable opportunities to complete the concrete driveway as promised. They failed to show numerous times. You had to purchase $97.24 of material, pay an additional $2,500 to get the rest of the driveway completed, and had to pay a secondary contractor $1,500, which gives us to the figure of $4,097.24. Is that correct?
Mostly, Your Honor. So I believe you're reading off the notes from.
I'm reading off your complaint.
Okay, so the $1,500 is actually above and beyond the total cost of the project that was originally quoted. So I actually paid $4,000 to the secondary contractor.
Yeah, that's, oh, gee. Yeah, 2,500 plus 1,500.
So can I go over the math with you real quick on it?
Yeah, well, you're asking for $4,097.24. Is that correct?
Yes, sir.
All right, so the 2,500 you had to pay to finish it, and the above and beyond cost of $1,500, which is $4,000. If I got that right?
Mostly. Can I try to explain it a little bit? And this is my math, I suppose. So ultimately, the total cost of the project was supposed to be $10,000. I paid initially $5,000 as a down payment, and the remaining $5,000 would be due the day the concrete was poured and finished. However, mid-project, Everlast Concrete decided to split the pourings, if you will, into two phases, a phase 1 and phase 2. So they actually required an additional $2,500 from me, which reluctantly I gave. So at this particular point, they had $7,500, had only completed part of the project. And then after numerous no-shows, basically I had to terminate their contract, find a secondary company that would then finish the job. And that the secondary company
Who finished the job for you?
It was actually a gentleman by the name of Brian. I believe you pronounce his last name Antles, Antles. I'm sorry, I don't know the full pronunciation of his last name. So really the additional $1,500 that you're referencing there, Your Honor, is due to my total project cost being $11,500 as opposed to the quoted $10,000 originally. So that's where that $1,500 difference comes into play.
Well, they aren't here to argue about it, and you supported your claim under oath. If he had been here, I would have raised the fact that I know you and your parents, and my wife's friends with your mom, and you went to school with my kids, but I don't feel the need to recuse myself. I think I could have fairly heard this matter, but it's a default. So, and you supported your claim with pleadings and under oath. So I find that they owe you $4,097.24 plus costs for a total of $4,229.94. So this is the easy part.
Yes,
Getting the money is the easy part. I mean, getting the judgment is the easy part. Getting the money is the hard part. Which house was this at?
This was at Sean's. And again, I apologize. I don't know his last name. I think you actually read it based on the proof of service report.
Yes.
Yeah, so it was at Sean's address in Granville.
But this is one of the, no. Where is the house? Which
Oh, I
Park
apologize.
Road?
Yes, on Moore Park Road in Three Rivers,
I'm trying to picture which house it is.
at the corner of Sunset and Moore Park Road on the southwest side.
All right, got it. All right, you prevail. Now, they have 30 days to pay this. If they don't pay it, you can do what the last lady did and do a discovery subpoena to compel them to come to court to discern why they should not pay on the debt. They're going to do the same thing. They're going to show up and say, hey, wait a minute. We wanted to say this. They didn't show up and a default judgment enters. So wait 30 days. If they don't pay, you can come to the court and ask for a discovery subpoena, which they will serve on them, which will compel them to appear under oath and be prepared to answer questions about their ability to pay on the debt. All right. I did not feel the need to recuse myself. They aren't here. It's a default. And so,
Your Honor, I do have a question on that.
all right.
Just obviously, I'll wait the 30 days. Is that something that the court reaches out to me? And ultimately, how do I go about doing the discovery subpoena? Is that something that I work through the court system on?
Yes, you'll have to come to the courthouse.
Okay.
And there's a fee. I can't remember how much it is. Isn't very much, $20, I think.
Okay.
And they'll set a hearing and then they'll have to be served. Now, the last one was served out of state, so it was $88. But they'll serve them and then they'll have to come. If they don't come, then they're subject to a show cause to show cause why they should not be held in contempt. And at that point, I could issue a warrant for their arrest. And although it's hard to arrest a company, Everlast LLC, but we'll cross that bridge when we get to it. Maybe this will wake them up. Certainly what often happens is when the discovery subpoena comes and they're compelled to come to court, you don't have to come to court if you're sued in a civil matter, small claims or otherwise. But if you don't show up, you automatically lose and a default judgment enters. But if you get a subpoena, that's a court order to appear. And if you don't show up for that, you're subject to contempt, which includes arrest. So let's see what happens. Maybe they'll get this and they'll mail you a check and everything will be fine. That doesn't happen very often, but sometimes it does.
Is this something that I should reach out to them directly and ask if we can come to an agreement outside of court? Or
Yes.
okay,
Yep.
I'm happy to do that. As a matter
Well,
of
you'll get this. Why don't you wait a week or so till they get a copy of this default judgment?
yes,
And
sir.
then you can contact them and say, hey, can we set up, $500 payments or something?
Okay.
But yes, all right. You're good to go. Thank you.
Thank you, Your Honor.
All right. All right. He's a nice young man. He's working on his little own real estate portfolio. Mr. Nieves, will you come forward? Good afternoon. This is another return to a case that I had previously heard. This is entitled David Nieves versus Jorge Medina Lopez. I set this matter for a hearing. Again, the whole file isn't here, but let me go into the electronic file. Mr. Nieves sued Mr. Medina Lopez for $5,300 for non-payment on I believe a sale of a car or something.
Yes.
I entered a judgment by consent. Mr. Medina Lopez acknowledged that he owed the money, and he agreed to make payments of $300 a month starting February 21st of 2025. I think he made just a couple and then paid no more. So he made one payment of $300. So Mr. Nieves has moved to set that installment payment order aside. And, then we did a discovery subpoena and we did some other things to attempt to get this. So we had another hearing earlier and he said he would pay $300 a month starting June 15th. And again, he didn't make the payments. Yes?
He actually made 2 payments of $300.
All right, so far he's paid $900.
No, 2 payments of.
He made the first payment, then he made another one after June.
He made June 14th and July 18th, and
Oh,
then, sorry.
All right, go ahead.
And then when the next one was due, he texted me the day that it was due, saying if I could wait for him a week. And I mean, I know we all get behind. I told him, that's fine or whatever. And then next week came by and I texted him, hey, I'll just see you in court. And then he just started going off that he got laid off and then that he's in a different job and a whole bunch of.
Well, this isn't much of a victory. I'm gonna grant your order to set aside his installment payments, which means you could garnish his wages. But he lives in Indiana. So I was trying to get you guys in the same place at the same, he made 1 payment, then he made 2 more payments. So he's paid $900 towards this $5,300 debt, but he didn't show up. I'm going to grant motion to set aside installment payment order, which means you can garnish his wages or his taxes or seize property, but it's hard to do when he's in a different state. That's why I'd hope to get him here and get him back on some sort of payment schedule. If he did lose his job, then I guess that explains why he isn't paying. All right. As far as you know, does he still live on Tulip Boulevard in Goshen?
I believe so.
All right. The motion to set aside installment payment orders is granted. A motion is granted and a writ of periodic garnishment may be issued, meaning you could garnish his wages. Again, he's in another state, so that's harder to do. Does he work anywhere for wages?
Forest River.
Well, you could garnish that. That's in Michigan? Indiana?
Well, Forest River's in Michigan and Indiana, so I don't know exactly what line or what plant he works in.
He won't like a garnishment very much. It can take a large percentage of his net income. But an installment payment order prohibits you from doing a garnishment. I'll have the bailiff take you out to see the clerk and you can ask a little bit about the garnishments. I'll give you a copy of that order granting your motion.
So, sorry.
Go ahead.
So, say that I garnish his check or
Yes,
his income or whatnot.
yes.
Do we have to come to court again, or?
You shouldn't. What he'll do is then he'll squeal because you're going to take 40% of his net. I don't know what the exact number is, but not as gross as net. And they take a large percentage of it out. And you don't have enough money to pay your car payment or your rent. Garnishment is quite harsh. It takes a certain percentage of your net. So he won't like it. So he may then file a motion for installment payments again. That's why I'd hoped he would be here so we could discuss it. Although if he doesn't file anything, they'll just take the money out of his check until you're paid.
Okay.
But he will probably file a motion at that point. All right, they'll give you a copy of the order and you can ask about the process.
Thank you.
All right, good luck, sir. Your diligence may pay off. All right, I also have Acker Mechanical versus Sierra Diata. This was a show cause hearing. This was a claim for $3,730 for some mechanical work that this company did at the Diata's property outside of Sturgis. the Deotas or Miss Deota did declare bankruptcy, but this case occurred after the bankruptcy was filed, so it was not included in the bankruptcy. She did agree on the amount. We had a discovery hearing, which was set for September 8th, and the defendant failed to appear. So they asked for a show cause hearing to show cause why she should not be found in contempt for failing to appear pursuant to the subpoena. But now neither side is here. So I don't know what the status of this is. Maybe the clerk knows. Maybe it was paid. All right, I guess no further action is needed at this time. All right, I think that finishes our day.